Hello, everyone, and welcome to today's webinar, Ready, Set, Plan, presented by the Office of Gift Planning and the Phoenix Society. My name is Denise Chan Gans, and I'm the Executive Director of Gift Planning here at the University of Chicago. I've been a member of the Gift Planning Office here for over 20 years, and I call this my professional home. On the slide, you will see a photo of me. I decided to include this photo because it shows how far back my affiliation to the University of Chicago goes. This is me standing on the shores of Lake Michigan wearing a University of Chicago sweatshirt given to me by my father, who was a medical resident at the university in the 1970s. I am so pleased that you have joined us today, and we are really thrilled to know that you are looking to the Office of Gift Planning as a resource for philanthropic and estate planning. Before I begin the program, I just want to mention a few housekeeping matters. Please keep your audio off during the presentation. Feel free to keep your video on. I can see some faces in the gallery to my right, but please keep your audio off. We welcome you to submit questions throughout the webinar. You can do that in the Q&A button. To ask a question, you can click the More button at the bottom of your screen, select Q&A to enable the Q&A button, and then submit your question. We will have time at the end where I'll be answering your questions live from the Q&A section. If you'd like to enable closed captioning, click on the CC at the bottom of your screen. Before I present the agenda and what we'll cover today, I just want to remind everyone that this presentation is for informational purposes only, and it's not intended to serve as legal or professional or tax advice for you. For advice or assistance with your unique and personal situation, you should really consult an attorney or another professional advisor. So while we hope this webinar is useful to you, I just want to be clear that I work for the university and that my role is really to facilitate plan gifts to the university. So my agenda for today is first to familiarize you with what an estate plan is. Then I will suggest some ways that you can prepare to put together an estate plan and prepare the information that will hopefully make your estate planning process manageable and successful. Later in the program, I'm going to discuss ways that you can stay motivated as you work on your plan, and I'll provide some tips for choosing attorneys, executors, trustees. This can often be decision points that become an obstacle for people when working on their estate plans. And finally, I'm going to share some ideas for structuring bequests and leave time, as I said, for discussion and questions. So first of all, what is an estate plan? Your estate is the sum of your financial assets at the time of your death, less your debts and liabilities. Your estate includes things like real estate, bank accounts, stocks and bonds, business interests you may have, your tangible personal property, meaning your personal belongings, retirement accounts, insurance and annuity policies, really anything that you have a ownership or property interest in. The process of estate planning really is about setting up your assets and putting into place documents that will govern how your estate will be distributed and administered after your death. Estate planning documents typically include a will, a trust, which is revocable typically, beneficiary designations. Just to clarify, the will is a document that will govern the assets that you own in your own name upon your death. Trust documents govern assets that are owned by the trust, including assets that may be added to the trust upon your passing. And beneficiary designations govern accounts such as IRAs, insurance, annuities. They can also include bank or brokerage accounts that allow beneficiary designations. So these three types of documentation, wills, trusts, and beneficiary designation, really govern where your assets will go and how they will be distributed. But an estate plan, if comprehensive, also should include planning for incapacity. And that includes documents like powers of attorney for property, powers of attorney for health care, and documents that state your end of life wishes, such as living wills and health directives. So we're going to pause for a moment. I'd like to take a poll of the audience and find out how many of you have an estate plan. So if you have an estate plan, that would be the first choice. If you don't have an estate plan and that's why you're here, that's choice number two. And if you're in the category of people who want to learn what an estate plan is, to understand whether you have one or not, that would be you in category three. So it looks like as the responses come in that it's pretty much split 50-50. Just less than 50% of you have an estate plan already, about less than 50 don't have an estate plan, and there's a small number of you who actually don't know whether you have maybe an adequate estate plan or not. So thank you for giving me a sense of who's in the audience today. I just want to take a moment to explain what happens for those of you, as much as 50% of the people attending the webinar that don't have an estate plan. What happens if you die without an estate plan? In that case, state law, which the laws are known as intestacy laws, will dictate where your estate is distributed. State laws typically leave estates without wills or governing documents to immediate family members, such as surviving spouses and children, but it does vary by state. You know, with some states leaving everything to the surviving spouse, other states might divide your estate between a surviving spouse and children. It is the case that intestacy laws typically do not include unmarried partners or non-adopted children, such as stepchildren, and they don't include non-relatives, such as friends, employees, charitable organizations. So these are all good reasons why you will want to take the time to put together an estate plan. Another thing that is true if you don't have an estate plan and you have minor children is that the court will decide who will serve as guardian for your children. By putting together an estate plan, you will have the opportunity, and this is an important decision, in choosing who will serve as guardian of your minor children. Without an estate plan, you will also miss the opportunity to avoid probate. So probate is a process in which the court oversees the verification of a will, the appointment of an executor or administrator, and the distribution of assets pursuant to a will. As I mentioned, a will govern all of the assets that you own in your own name that aren't otherwise passing by beneficiary designation. Probate then also involves typically an attorney who's going to appear in probate court on behalf of the estate. This can involve additional time and cost. And it's also important to note that when you have a probate estate, the will is admitted into the public record. So that is also something that can be, your privacy can be better protected if you do some estate planning that puts the majority of your distributive provisions in a trust rather than a will, because it's the will that gets admitted to probate court, not necessarily the trust. So just to recap, if you go through the estate planning process, you will likely go through the process of setting up a trust. And by moving assets into that trust during your lifetime, that will leave little, if anything, passing pursuant to the will. And therefore, you will have successfully avoided the need for a probate process upon your passing, because all of your assets will be effectively governed and distributed by a trust or beneficiary designation instead. So, all very good reasons to take the time to put together an estate plan. The other opportunity that you don't have when you you don't have an estate plan is that you miss the opportunity to do tax planning. The current estate tax exemption is 15 million per person, 30 million for a married couple. So it is quite high. It doesn't apply to most people, but should you be in the range of being subject to estate tax because your estate is near that level, then you certainly will want to consult an attorney and put documents in place that help you avoid some of those estate taxes. There are also state inheritance taxes that come into play. In Illinois, the estate tax exemption is 4 million. So again, good reasons to consult an attorney and set up trusts and structures within your plans to minimize those transfer taxes. I'll also mention that there are some assets passing at death that carry with them income tax liabilities. And again, there are strategies and ways to structure the beneficiaries and the sourcing of gifts to minimize those income taxes after your passing. So I want to move on to our next poll question. For those of you who answered that you do have an estate plan, I'm interested to hear when was the last time you reviewed your estate plan? So was it in the last year? Was it 1 to 3 years ago? Maybe more than 3 years ago? Or perhaps you put together an estate plan and you really haven't ever reviewed it. So as the answers come in, it looks like it is split fairly evenly, with the most individuals saying that it's actually been over 3 years since they've reviewed their estate plan. So I'm going to talk in a little bit about when is the best time to review one's estate plan. And hopefully this webinar will motivate those of you who are due to review the estate plan to do so with confidence and some tools. So, as I said, I'm going to talk about when is the right time to review an estate plan or put together an estate plan, which would apply to many of you who maybe haven't done so. So let's take a moment at some life events that should prompt a review and update of your estate plan. First, getting married or divorced. These events can really impact your legal and financial situation. And it would be at that time that you would really want to revisit your estate documents to ensure that your wishes reflect your new circumstances and the change of relationships in your life. Another good time to review an estate plan or have an estate plan for sure is when you are buying a home. Owning real estate is one of the many reasons that people set up a trust in their estate plans, given that it is a big asset. And if it's held in your own name, would pass by will. Using a trust is really an effective way to retitle that asset in the name of a trust so that it doesn't trigger probate upon your death. Um, of course, having children is another major milestone. As I mentioned, you want to nominate guardians for your children using a will and make plans for their inheritance and financial support, especially while they're minors. If you have a change in financial circumstances, like you've received an inheritance, you're starting a business, you have experienced a windfall, that's really an important time for you to plan for those new assets and potentially any new tax liabilities that you may be subject to. And lastly, health events can happen at any time. So not only will a health event maybe motivate you to think in more detail about how you want your estate to be distributed and how you want to be remembered, but you also will want to think about and review who is going to handle your health decisions if you're unable to do so yourself, and if you've clearly stated your wishes for end-of-life care. The general rule is, in addition to these different life events, is to review your estate plans about every 3 years. That is sort of the industry standard. And certainly when there's maybe big tax law changes would be another time that you'd want to review your estate plan. So moving on, I have the last of our poll questions. And this will help us move towards how to prepare oneself to put together an estate plan or review an estate plan. And my question is, what best describes how you feel about estate planning or your estate plan? So you can answer that you feel comfortable with your estate plan. You might be someone who is concerned about your estate plan, or you might be someone who actually feels really overwhelmed by estate planning or the prospect of having to update your estate plan. So it looks like a good portion of you feel concerned about your estate plan. So I want through this webinar to hopefully bring you some information that will help you calm your anxiety about doing estate plan and give you some ways of framing the process of estate planning that will help you move forward. So as I'm sure many of you can relate, estate planning is a task that's easy to push to the bottom of the to-do list because of how it makes you feel. Not only can the task and the paperwork feel burdensome, but it can be exacerbated by uncomfortable emotions about mortality, family situations, and your value. I want to just talk through 3 sort of mental blocks that can often hold people back and suggest ways that you can reframe them to move forward with a greater sense of positivity and confidence. So one of the most obvious roadblocks for people is really just confronting mortality. So it is hard to spend time sort of mapping out scenarios about what will happen at the end of your life and after your passing. And so it's easy to avoid time spent on this task. But one way to get past this anxiety and avoidance is to shift your focus from confronting mortality to creating a legacy. This takes the focus away from an end date and really refocuses the purpose of estate planning on the future. So it becomes about deciding how your values and your hard work and your story can be structured to protect and support the people and the causes that you care about and how you will be remembered. Another thing that is hard to overcome is really what feels like a lot of overwhelming decisions. So it's easy to feel paralyzed by the number of documents and some of the legal and tax ramifications of estate planning. And it can feel sort of like a mountain of decision making and administration. But the reframe for this is that you don't want to surrender to what feels insurmountable. Going through the process of estate planning will really help you gain a sense of control and empowerment. As I mentioned, if you don't have a plan, state law and a probate court is going to decide what happens with your hard-earned estate. So establishing and implementing a plan takes the power away from intestacy laws and really gives it back to you. So you have the power and the autonomy to decide how your estate will be handled, who administers, and who it supports. So that's something that you should continue to remind yourself in moments where you feel like the process of putting together an estate plan is very burdensome. And third, estate planning is often held back because we're worried about family issues. So we are worried that estate planning and estate planning decisions will spark uncomfortable conversations, might create tension. It might really mean you have to sort of face some family dynamics. But the truth of the matter is, leaving without a plan is often what really creates family conflict. So recognize that an estate plan is really giving a gift to your family. It gives them the gift of clarity, and it really relieves them of a burden. So when you take the time to map out your wishes clearly, you save your family from having to guess at what you wanted and potentially disagree with one another during what's already a traumatic time for them. So by doing your estate plan, you really are providing a safer space for your family and giving the gift of knowing what you wanted for them. So I'm just going to run through a couple of what may seem obvious practical tips for working on your estate plan to keep yourself engaged and motivated and moving forward. These are sort of typical executive functioning skills, but I like to apply them to the estate planning process. So one thing you can do is break up the project of estate planning into small segments. Um, One of the big tasks of estate planning is getting organized. So you could create micro tasks, like just do one page of an estate planning organizer at a time, locate one statement for a financial account a day. You might also think about creating a reward system. So you could create a timeline that ends with a family vacation or a reunion or an event that you're really looking forward to. Um, Another idea is to find an accountability partner. So this would be someone that you check in with on an occasional basis to keep you accountable for the progress you're making. One idea would be a ride-along accountability partner. That would be maybe finding a friend or a colleague who's also working on their estate plan so you can share how it's going, and maybe complain a little bit and also congratulate each other on your accomplishments as you move forward. Another idea is to choose a stakeholder accountability partner. That would be perhaps an advisor like an attorney, perhaps even an organization that you've named in your estate plan, a representative from a charity, somebody who has an incentive to check in with you periodically about the progress you've made in your estate plans. Finally, one idea is to try and make the estate planning process more fun is to make it into a game. I'm not sure if you know, but this past academic year at the university was dubbed the Year of Games, and it explored how games shape culture, spark creativity, and foster connection. So we didn't have time to ask a U Chicago student to gamify estate planning, but in truth, with the help of AI, we came up with an idea for a visual quest map, making estate planning into something like a Dungeons and Dragons journey. And you can see here on the slide, the goal is to progress to higher levels and complete the task with the ceremony. So the first level would be discovering your loot, inventorying your financial information. Moving on, you would try to reach level 2, where you choose your executors, guardians, powers of attorney. Level 3 is the point at which you actually decide how your kingdom or your assets will be divided. Level 4 is the point at which you meet with your attorney, or maybe you are starting with a digital platform and you're using a scribe to put your plans in writing. And then level 5 would be the final seal, the execution ceremony, and being able to celebrate that your quest is complete. So, kind of rewinding a little bit, what can you do to prepare for a meeting with an attorney and to really start the process of estate planning? The first thing you want to do is really start by organizing your information. So that's gathering details about your family members, their names, relationships, contact information. You'll also want to create a list of your advisors and fiduciaries, things like your financial planner, attorneys, contacts at banks and brokerage accounts. That way, your family and your estate representatives will be able to easily get in contact with these individuals when the time comes. You do want to take the time to sit down and inventory what you own, inventory what comprises your estate. And of course, give some thought to what your objectives are. Do you want to leave specific gifts to family, friends, or charities? Are there special instructions you want carried out? Putting this in writing really helps clarify your intentions and will save time when you meet with your attorney. We have created an estate planning organizer, and my colleague is going to put a link to that estate planning organizer into the chat. And we hope this is a useful tool for collecting all of this information in one place. We will also be emailing this out to you after the presentation is over. Don't forget about digital assets. This means inventorying digital accounts, having your email information kept somewhere. This includes usernames and passwords. You want to find a mechanism to save these, share this information after you're gone, and keep it safe. I want to mention that there's a lot of online resources, templates, checklists, and organizers that you can take advantage of. You really don't have to look too far. AARP has a personal estate planning kit that you can download for free. As I was poking around, I also found that Fidelity has an estate planning service, an online sort of portal that will help you get organized. So while I'm not endorsing Fidelity per se, I just want you to know that there's a lot of good resources out there. So one way to sort of stay motivated as you do your estate plan is to incorporate personal aspects. These are things that can really make the process more meaningful and enjoyable. This is things like planning for your pets, thinking about the heirlooms that you want to leave to others, jewelry, art, or cherished family possessions, making sure that you specify who receives these items to make sure that they're enjoyed and treasured by the people who receive them. You can also think about writing an ethical will or a letter of wishes. These aren't legal documents, but they give you an opportunity to share your values, your life lessons, and your hopes for your loved ones. You might consider including a family recipe in your estate plan. Food is certainly something that is connects generations, and sharing a recipe can really keep a family tradition alive. And finally, you might consider creating a video message or maybe even incorporating photos somewhere into your estate plan. So, I want to turn now to give you some recommendations about choosing executors and trustees. So, first and foremost, what do executors and trustees do? These are the people who carry out your wishes when you're gone, pursuant to the documents that you have in place. So, an executor is typically responsible for gathering your assets upon your death, stewarding those assets, completing the administrative and tax responsibilities of your estate, distributing assets pursuant to a will. In short, it's really the project manager of your estate, getting things organized and making sure things are done to plan. Um, a trustee is the person who is going to do all of these tasks with respect to assets that are held in trust. Oftentimes, trusts may last for periods of time. So, a trustee is also responsible for managing assets as long as they're in the trust, making distributions from the trust to beneficiaries, perhaps according to the terms of their trusts. Um, Trustees also are responsible for keeping trust accountings, filing tax returns. Um, Executors and trustees, their roles do overlap sometimes, especially immediately after one's passing. They can be the same person, so you can name the same person as executor or trustee. Um, Things to really keep in mind when choosing a trustee or an executor is their competency. So it's important to choose somebody who has experience, who is organized and efficient. So being an executor or trustee is more than just sort of an honorary title. They really have a job to do. Um, so you want to choose somebody who is able to meet deadlines, is comfortable, really dealing with finances and handling paperwork and communicating with perhaps attorneys and financial custodians and accountants. Um, you also really want to keep in mind continuity. So you want to be able to choose somebody who is going to be available at the time they're needed. So think about where the person lives, what life stage they're in. Settling in a state or managing a trust does often involve a physical presence. So, sorting your belongings, maintaining a residence, it's very, very helpful to have somebody who can be present for those tasks. And it does take 12 to 18 months, maybe even longer. So you want somebody who really has the bandwidth to do that. So moving on, in terms of costs, I just want to mention, so you can choose individuals as executors and trustees. You also have the option of choosing a corporation. There are corporate trustees, banks and trust companies. Corporate trustees do charge a fee. They often have minimum thresholds. You can look to private individual fiduciaries who are not connected to banks or financial institutions who provide that service. They need to be licensed in certain states. You can also consider combining or using co-trustees. So you might have an individual trustee who's working alongside a corporate or a professional fiduciary. Um, Executors are typically paid out of the estate's assets, and their fees range between 1 and 5% of the estate's total value. Sometimes the executor's fee is dictated by state law. Um, the fee for trustees for reasonable compensation, if it's a corporate or a professional trustee, they are charging between 1 and 2%. If it's an individual trustee, a reasonable compensation for an individual trustee is more like 0.5 to 1.5%. I just want to quickly mention that the university cannot serve as executor or trustee of an estate or a trust. We're just not set up to administer those tasks on behalf of individuals. Um, I really need to move quickly through these slides because I know I want to leave time for questions, but um, here are some suggestions for choosing an attorney. One of the main questions people ask is, do I need an attorney? There is no legal requirement that you have an attorney prepare your estate plan, um, but there are legal requirements in each state for the valid execution of a will and also trust documents. So you really do want to have an attorney helping you to make sure that everything's properly executed. And certainly, if you own real estate, you own different types of assets, you have maybe a more complicated family situation, then it really is recommended that you find an attorney. Um, Many people ask, how do I choose an attorney? We are putting into the chat an article that we wrote in our newsletter called How to Choose the Right Estate Planning Attorney. Um, it's important to find somebody who does specialize in estate planning because estate law varies by state and regulations and tax laws regularly change. You do want a dedicated specialist. Um, if you really don't know where to start, I would suggest that you ask friends, neighbors, family, work colleagues for recommendations in your community. There's also an organization called the American College of Trust and Estate Counsel. That's a national organization of estate planning attorneys who, in order to be a member of that college, demonstrate the highest level of professionalism in wills and trusts and estate planning. You should take the time to interview estate planning attorneys. So you can ask what percentage of your practice is dedicated to estate planning. You can ask how they charge, if it's a flat fee or an hourly rate. And you can ask them, what's the process if you need to update the plan in the future or you have questions in between execution of documents. A word about online providers. There are now a lot of um, online providers where you can put together a will using their services. But while they may be good for really simple plans, it's really important to have an attorney review anything that you put together, and that would be provided by an online service. Um, and in terms of cost, a basic will typically ranges between $500 and $1,500. If you're doing a will and a trust package, it could run anywhere between 1,000 and 5,000. If you have a really comprehensive attorney-led estate plan, that often starts, around 2,000, 2,500, and can go up to 5,000 and up from there. So, my final slide before we move to questions and takeaways is structuring bequests. So, these are a list of sort of the different ways that you can design your gifts to heirs and charities. You can leave things specifically, like a specific sum of money or a piece of property. You can set up conditional bequests, so you can leave gifts that only happen if certain criteria or conditions are met. You can use formulas so that the size of a gift might depend on the size of your estate or might be tied to certain tax exemption amounts so that you can maximize tax savings. Um, Especially in the world of trusts and trusts that might be set up for the benefit of others. You can use standards that will guide how distributions are made to beneficiaries. And this is a way to ensure that maybe beneficiaries don't spend down all of the money at once. And Then, of course, there are residuary bequests, which means leaving the residue of your estate after all other specific amounts and taxes and debts are paid. Residuary bequests are often phrased as percentages or fractions of that residuary estate. And of course, I want to mention charitable bequests. These can be specific, residuary, they can be subject to formulas. Um, but I want you to know that for charitable bequests, you can not just name the charity, you can designate a purpose. With the university, you can establish endowed funds at certain levels. And we use something called a bequest letter of direction to help people design their charitable bequest purposes. So, some key takeaways: really start by gathering information, try to keep a positive mindset, break up the work and keep it interesting. Choose your fiduciaries carefully and consider perhaps using third parties if you don't have immediate family members or friends that that you can think of naming. Use available resources, but really still consult with an attorney and design bequests that reflect your intent. So we have about 20 minutes left, the majority of which I'd like to spend answering your questions. So, one of the questions we got to kick us off from the registrations was, if I have a will, do I also need a trust? So, as I mentioned, a will will govern all of the assets that you own at the time of your death. Um, you don't need a trust necessarily. A trust really doesn't have a purpose unless you put things into that trust. So you could rely, if you have a simpler plan, simply on a will and things like beneficiary designations. But as I mentioned, using a trust is a very good mechanism to avoid probate if that's important to you, so that you don't have the added, or your estate does not have that added expense and cost. Um, and so many people do have revocable trusts, and nowadays it is part of sort of a complete estate plan is to have a will, a revocable trust, and those powers of attorney. So, oh, I was just told to stop my share. So, are there other questions I can answer? Okay. Um, One of the questions that we got is about what changes if I move states? Which state should my estate plan be created in? So it is the case that the state in which you pass away is the state law that will govern your estate, whether or not you need to have probate. It would be the place where a probate is opened. Um, but if you execute wills and trusts in one state and you move to another state, um, states have a reciprocity. So it doesn't mean that if you execute documents in one state and move to another state that all of a sudden your documents are no longer valid, because states will respect the validity um, uh, laws of other states in determining at the time of death whether your will is valid. Um, that being said, if you move residence and move to another state, different inheritance tax laws may apply. Um, so that is a very good reason to check in with an estate planning attorney in your new state. And of course, if you plan to spend the majority of your time and the rest of your life in the new state that you've moved into, um, it would be most convenient if you chose an advisor who was located really in the same place as where you anticipate passing away. Um, let's see. Oh, I see a lot of questions in the chat. Let's see. Um, so one of the questions that we got is, how do I know if there's something that I've missed or whether my estate plan has gaps? Um, this is a good reason to revisit your estate plan periodically with an attorney. It's also one reason, as I mentioned, when you're preparing to put together an estate plan, you want to sort of make lists and put all in one place, like your family members, your objectives, all the assets that you own. And that is a very good way of realizing that, oh, I have this account that I forgot about. I haven't checked the beneficiary designation on that for a very long time. I have an account that or some stocks that I acquired or inherited a very long time ago. That's something that I need to retitle in the name of my trust. So sort of reviewing the inventory alongside your estate plan is one way to maybe identify things that you've missed or that you haven't thought about. Um, let's see. Um, so I got a question here. Oh, here is a question about joint revocable trusts or separate trusts. So there are states that have community property, and those states, uh, people who living in those states do often make use of what's called a joint trust. So a joint trust is where spouses will put together a trust document that they are essentially both the grantors and the trustees of. It's sort of a coordinated plan that lives all in one trust document instead of having a separate trust document for the husband and a separate trust document for the wife. The question of whether or not you should have a joint trust, again, is really something that you should consult an estate planning attorney about. It will depend on perhaps what state you live in, if you live in a community property state, and also what your desired outcomes are as a couple with respect to your estate plan. So I would say that in my experience, most couples have separate trusts, separate wills, obviously, but there might be some cases where a joint trust makes sense. Let's see. This is a bit of an outlier question, but I'll answer it because it's here in the chat. We got a question about using IRA, qualified charitable distributions, to fund gift annuities. And I'll kind of use this as a plug for really all of the types of gifts that we work on here in the Office of Gift Planning. So we're certainly here to help you with charitable bequests to the university, to help you put in writing how you want your bequest to be used, bequest letters of direction. We can help with naming the university as beneficiary of IRAs and things of that nature. But we also help people set up what we call life income gifts. These are charitable gift annuities and charitable remainder trusts. These are actually irrevocable arrangements, irrevocable trusts in the case of a charitable remainder trust. They afford you a charitable deduction when you make the contribution into the arrangement. They will pay you a stream of income, typically for the rest of your life. Um, and it's the remainder amount in the annuity or the trust that will come to the university um, and benefit the university, much like a bequest would. So, about 2 years ago, a law was passed that allows you to use a qualified charitable distribution, which was previously only allowable to make outright gifts, now can be used to fund a charitable gift annuity. It is a one-time, once-in-a-lifetime allowance, currently of 55,000. So that's something to be aware of, something we'd be happy to speak with you about. Um, Note that qualified charitable distributions, you have to be 70 and a half or older to take advantage of those. Let's see. Here's a question. So somebody put into the Q&A, our son is executor of our will. How can we be sure that the funds to charity go where we chose um, after our death? So just upon reading that, I would say, sort of circling back to choosing executors and trustees and what does a fiduciary really do? As a matter of law, a fiduciary has a legal obligation to carry out the terms of the will or the trust, to preserve and protect the estate. And so, if you have specific charities named in your will, whoever you name as executor, whether it's a family member or someone else, has a duty to distribute that amount or that share to the charitable beneficiary. Now, if you leave your charitable bequest to something like a charitable entity, such as a foundation or a donor advised fund, then it will be important that you leave instructions with the foundation or with the successor advisors, or in some way documented with the donor advised fund, how you want the assets of those charitable entities to be distributed. So I encourage you, if you know the ultimate destination of a charitable gift, to put that directly into your will or trust. Um, I think I have time for one more question. Um, so would you provide some background on tax advantage giving while one is alive, and how to bequeath assets, receive a tax benefit, but only disperse the asset after demise? Um, if we're talking about amounts left upon death, not during life, um, as I mentioned, the estate tax exemption is 15 million per person, currently 30 million for a couple. So if you are above that amount, what estate tax planning would look like for you in your estate plan is primarily, and again, I can't give legal advice and you should consult an attorney, but it involves setting up trusts that will ensure that both spouses' exemption can be fully utilized. So when one spouse dies and leaves assets to the other spouse, there is the ability to set up trusts so that the full exemption amounts are used across both people's sort of estates and um, at the time of their passing. So that's one way. And In terms of income tax planning, which is really a separate tax liability on one's estate, there are assets like traditional IRAs that, while they're remaining in the plan or the account, have not been subject to income tax. It means that if you leave IRAs to non-charitable beneficiaries, they will be subject to income tax as they're withdrawn by the beneficiary. Now, the rule is that typically you have to withdraw the full amount of those accounts within 10 years. It used to be the case that you could stretch them out over a long period. So there are choices to make about how you source gifts to different parties in your estate plan. Often the recommendation is to leave um, individual retirement accounts that are not yet taxed to charities because charities will not have to pay tax when they receive those assets, and to leave other assets to non-charitable beneficiaries, in which case they'll often get, the benefit of a step up in basis and things like that. So I hope that gives you kind of a little bit of an idea of what some basic estate and income tax planning might look like in one's estate plan. So I think that is the last question. And I want to now move to the last slide, which is really to provide you with my contact information and contact information for the Office of Gift Planning. We really invite you to reach out if you have any remaining questions. This is our general email as well as my personal email address. You can browse our website where we have a lot of great resources, and we have a video library with recordings of all of our past webinars on topics such as charitable gift annuities, remainder trust, gifts of real estate, and giving through your IRA. I want to just take a moment in the last few minutes to mention that you may have seen last Friday that the president announced the university's new campaign called Chicago Minds. So if you would allow me just for a second to define what Chicago Minds means. Relentless, intrepid, creative. Since the University of Chicago's founding in 1890, Chicago minds have asked the hard questions and transformed our world. These are the minds behind the breakthroughs, the new schools of thought, the care that changes lives. Chicago minds take on the work that moves the world forward. And in the words of President Oliver Santos, at the University of Chicago, we are devoted to the cultivation of the human mind that pursues knowledge at the highest level, and this upcoming campaign is designed to honor that. So with that, and to close out the webinar, as you formulate your estate plan and think about your values and the legacy that you want to leave and what the University of Chicago has meant to you, please remember that the Office of Gift Planning is here as a partner and a resource for you. We want to help you design a planned gift that maximizes impact, minimizes taxes, and we want to help you clearly communicate your bequest intentions to ensure that they will be honored and fulfilled. So we are more than happy to take meetings with you to have an exploratory conversation. And we hope that including a charitable bequest in your estate plan might also help you to and keep you motivated to successfully complete the plan. I would be remiss if I didn't mention the Phoenix Society, our community of planned gift donors, and we would be honored to include you as a member if you have a charitable bequest for the university. And finally, I really want to give special thanks to Matt DiStefano and Brenda Lee Johnson, members of the gift planning team, for all of their hard work in putting this webinar on today. So thank you so much for being with me today. I look forward to seeing you at our next webinar, or better yet, meet you at an upcoming campaign event. So thank you so much. I hope you found this useful and have a wonderful day.